trust we had a productive evening last night, and I understand that the parties have a proposal with regard to at least a portion of Mr. Copeland's testimony. Sorry, I didn't have this turned on. So what I said was I trust everybody had a productive evening, and I understand that there is a proposal with regard to at least a portion of Mr. Copeland's testimony, so I'll hear what that might be.
Good morning, Your Honor.
Morning.
Simone Hilton for the state of Georgia. Last evening, myself and Mr. Shard had a brief conversation regarding the testimony of Mr. Copeland.
Yes.
I believe the defense counsel have to speak among themselves in order to determine what portions of Mr. Copeland's testimony they are asking to be kept. And so we believe that we need a copy of the transcript.
Okay.
So that they can have that conversation. Once defense counsel has that conversation, then they'll speak with the state about their proposals and we can move forward from there, Your Honor.
All right, so I don't believe that I think we have the 7th available. I don't know that we have the 11th and 12th yet, but I think we've reached out this morning to Ms. Weaver, the court reporter, and I know she has some other people working with her as well, so we'll endeavor to get that to y'all as soon as possible. And she's been pretty fast with the turnaround, so we may even have parts of it by the end of the day. So that seems like a reasonable approach. And then I would think that the next thing we can do, to the extent y'all feel like you want to revisit evidentiary issues with regard to any of the videos, or I don't think you had gotten to the jail calls yet anyway, but with regard to the videos, we can probably do that now. Y'all think? Otherwise, give me something else we can do this morning.
Yes, we can do that. If you can, we just need to get that material very quickly to the office. To the courtroom. But we can do that.
All right. Send somebody to go do that, please. And has anybody thought through yet, and maybe we'll have ready soon, any kind of potential instructions for what we're going to be telling the jury about either Mr. Copeland's testimony, well, I guess generally Mr. Copeland's testimony, and then I'll entertain what we're going to, I am going to say about the fact that here I am instead of Judge Glanville. But for that, I'm thinking essentially just, I don't know, some matter has required a substitution of judges, and that's about it. I don't plan to tell them really much more than that. They don't need to know why.
Your Honor, given the conversation Ms. Hilton had with the defense last night, in that some of them may be seeking to have some portions of it kept, depending on the court's decisions regarding our respective positions, I don't think we can craft at this point. For instance, if we decided, everybody said, let's just keep it, then we would just keep it, understanding that's likely not going to be the case until we know the respective positions and the court's ruling on that. I don't think we could endeavor to craft it.
Yeah, that may be true. Okay. Yes, sir.
Good morning, Your Honor.
Good morning.
Good morning to everyone. Your Honor, I would, and Mr. Adams can opt out of this if he believes it, but I'm objecting to anything except the unvarnished truth about Judge Glanville. I would like the court to tell the jurors the truth, that he has been found to be disqualified and removed from this case for his conduct. And that's my instruction that I worked on. That's what I'd like you to do.
All right, well, I'll consider everything once I've got everybody's proposed instruction, to the extent anybody wants to provide one for me to think about.
Thank you.
And Your Honor, I believe that the statute, if I'm not mistaken, regarding recusal specifically, speaks to the fact that that is not to be made a portion of the case in chief, of the main case. I will get the exact language that I'm speaking of.
All right, great, thank you, I appreciate that. Okay, anything else?
Yes, Your Honor. We also briefly discussed yesterday the exhibit list, talking about how we can resolve working through the exhibit list. And my understanding from Mr. Shard, and I'm not sure if Mr. Kokomo was finished yet, but Mr. Kokomo, who's his legal assistant, and another legal assistant, we're actually working through the same thing that our legal assistant is working through. And our hope is, hopefully the court will be okay with this, by next Wednesday.
A transcript of an ex parte meeting that occurred on Friday.
Right, this is the
Before
one.
the Monday.
Sorry, sorry, just so that we're clear for the record purposes. This is the transcript I gave y'all at the end of yesterday that reflects Ms. Love had said, oh, yeah, we had, and in court on the record, but ex parte discussion that led to the Monday, June 10th ex parte. So that's what you're talking about?
Let me be more artful, yes.
Okay.
We were made aware, leading to the recusal of Judge Glanville, that there was an ex parte meeting that occurred on June 10th, Monday, June 10th. We were not told by the state, we're not told by the judge that that had occurred. We found out about it, luckily, and by happenstance. We then demanded a transcript. We complained about said ex parte, inappropriate ex parte meeting. At no point, when the court finally acknowledged that there was an ex parte meeting that occurred on Monday, June 10th, at no point did the court or the state at that point acknowledge, oh, by the way, there was another ex parte meeting that occurred on June 7th. We sat there after finding out about one ex parte meeting and having to drag the truth out. We sat there and the state and their co-conspirator, the trial court, were silent about the first ex parte meeting that happened on June 7th. What happened in that meeting on June 7th? The state went in and disparaged defense counsel. The state, with no one else there, trashed a fellow member of the bar, Mr. Melnick, trashed another fellow member of the bar, Caleb Bumpus, presumed the guilt of all these individuals, including my client, Shannon Stillwell, and all but accused myself and Mr. Steele of being co-conspirators in this YSL enterprise. And the judge agreed. And the judge said in this ex parte meeting, yes, I've observed these things. The judge presumed the guilt of all the defendants. The judge presumed the guilt of myself and co-counsel, Mr. Steele. And all this, people have been saying to me throughout this whole trial, why does Judge Glanville have it out for you? And it never made sense. And I don't assume bad motives of anyone. Why did Judge Glanville, when you did nothing wrong, try to throw you in jail? Accuse you of cussing him out in open court when you didn't do anything? Why does he always tell you, yell at you, tell you to sit down and be quiet? Why does he cut you off at every opportunity? Why did he try to throw Brian Steele in jail for 20 days for doing what was right? And I didn't have an answer. And then yesterday I received, and I appreciate that, Judge. I appreciate someone finally being open about what's going on here. And I received a transcript. And in that transcript, the trial judge, who's not only assuming the guilt of my client, but is assuming the guilt of me and my friend, Mr. Steele. This is gross. This is disgusting. But it's all starting to make sense. It clicked when I read that transcript last night. This is not okay. Nothing about this is okay. These gentlemen have a right to a fair and impartial judge. And I appreciate the fact that you are going to be a fair and impartial judge. But the reality, Judge, is that they don't have a right to a fair and impartial judge starting on witness 76 of a trial after 9 months or whatever it is. They have the right to a fair and impartial judge from the beginning. And this is absolutely gross and disgusting. And the bottom line is there's a lot more discussions that need to be had about this. But the bottom line is, if you ask me, do we need to revisit the rulings of the judge who sits in chambers secretly and talks to the other side and says, yes, I've been observing this. I've been observing this about what's going on in the trial. The judge that says, not only I'm going to meet with you on Friday and on Monday, but if we need to talk during the weekend, yeah, we can do that. The judge that suggests handing Mr. Copeland a list of questions.
All right.
Do we need to revisit those rulings? Absolutely, we need to revisit those rulings. We need to revisit everything. This is broken, and it's not okay. It's not okay. It's offensive, and it's not your fault, Judge. You didn't do this. I'm not trying to raise my voice at you. I'm heated right now.
I can tell.
My steam's been coming off my bald head all night. Nothing about this is okay. Yes, we need to revisit everything. That's my stance.
Okay, thank you. And I think that I understand you being upset, and I understand why you and probably some of your fellow defense counsel on this side of the room are upset. I do not think that everything you said is a fair characterization of what that June 7th transcript reflects. But once we have the official copy, that'll be made a part of the record, and that will show what actually happened, what actually was said. As to any kind of legal error that may have been made with regard to rulings prior to Mr. Copeland's testimony, assuming this case goes forward and assuming there is any kind of conviction, I then assumed that there will be a motion for new trial phase, which at that point I can appropriately revisit things, and then potentially an appeal, at which point those things can be raised. I am considering and reading what y'all gave me yesterday to make a ruling on the substantive matters of that ex parte, and I can consider the June 7th ex parte as well, because I suspect y'all will ask me to do that. And if I determine that that is such, that there was coercion that is unconstitutional or structural error, then I will grant a mistrial. Anybody? Does everybody have Mr. Zachary's statements?
Yes.
Okay.
That's fine. All right, I'll take the hit here.
They do keep sending you up here to be the one.
That's okay. I'll take the hit. So there are thousands and thousands of pages, and probably thousands and thousands of pages of transcripts. So we have a digital copy. I'm sure someone has the full discovery here, but we all have printed out copies of his statements. I know my copy
Y'all are all old like me and you like paper.
And because we have our notes on the paper too. And so
Yeah.
I didn't know that Zachary's statements were going to be on the agenda for today. So
Yeah.
I didn't bring the transcripts with all my
Yeah,
notes.
I mean, they shouldn't have been on the agenda because Kenneth Copeland was the agenda today, but.
Understood.
Okay, yeah, I hear you. You're not ready, but you can be ready soon. So when you say thousands of pages, do you mean period or thousands of pages for Mr. Zachary?
Mr. Zachary, to my recollection, has at least two, I believe maybe three statements.
Okay.
And I'm estimating here, I would say a total of about 9 hours of
Okay.
talking.
All right. Has the state determined whether, so I know, like, for example, for Kenneth Copeland's jail calls, I think you had 11, but you said we're only interested in 6 of them. Have y'all done that type of winnowing for Mr. Zachary and the other witnesses that you're going to be getting to soon?
We have been, not entirely winnowed, as the court said, down. We have identified jail calls of particular, not witnesses, but defendants that we intended to use. And when the court says particular witnesses.
I mean, Mr. Zachary is a witness, right?
But I don't have, I don't believe that we have any jail calls from Quindarius Zachary.
Oh, no, I was just using that as an example of winnowing. I'm not asking about jail calls from Mr. Zachary. I'm asking about whatever you think you might use with Mr. Zachary. If there are 3 statements, for instance, do you intend to use the entirety of all 3 statements? And if not, could you pinpoint for the defense what portions of those statements you intend to use so that if they have an objection to something you're not going to use, they don't even need to look at that because you don't intend to use it. So you can say, here's the portions we think we want to use, and then they can say, only look at those. Here are the objections we have.
Yes, I can do that. I have not broken it apart by
Okay.
segment scientific use, as I wasn't yet.
At him. I don't know when he's going to come in, but all right. So as a part of all of the work y'all are going to be doing before the 5th, that's going to be part of what you need to do.
And not just for him, just so that.
No, yeah, for everybody, for your next 30 witnesses, and then for your next 30 after that.
And so if, not trying to tell the court how to use the court's time, but if during.
I'm open to suggestions since what I've come up with so far isn't working.
What I can do, what we can do as a prosecution team, over the next, however amount of time the court wishes to allow us, is to identify with respect to each of the witnesses that are co-conspirators. I know that there are several. We can, and that it will be coming up in the next batch of 30 witnesses. So we can identify, just to the court and the defense, those people, and begin looking at the portions of their statements, their respective statements, that we would anticipate needing to use as opposed to using the whole thing.
Okay.
And so we should be able, over whatever amount of time the court gives us from here forward today, to go through and come back today with a chunk of statements for each of those people.
Okay.
If not all of them.
Okay.
Some of them.
I like what I'm hearing there, that by the end of today, she have done that for all of them. Yes, I like that.
Just,
Yes,
I said it, so
you did say it.
there we go. But I might overshot.
You might have overshot. All right, well, hey, if you can even do it for one, that'll give us something to work on. And I thought you said you could do that before the end of today. Okay, so.
Oh man, so we back at it with the craziest trial in history. YSL Rico, day 103. So new development in the case, man. There's been revealed that there was another ex parte meeting, as you've seen, with the prosecutors and the judge involving or discussing, the Kenneth Copeland thing and other matters of that sort. This is time number 2 where they're having secret, and this was before. This led up to the ex parte meeting that everybody knows about. Lawyer Sharp said that they just found out luckily. Come on, bro. How many more errors? How many more, not just errors, but significant errors do we need, bro? Like, at the least, it needs to be a mistrial, bro. At the least. I ain't saying let anybody go free, because I know people going to be opposed to that. But come on, broski. Another one, and in my DJ Khaled voice, another one. You feel me? I don't quite understand how they, meaning the courts, are able to get away with this so many times. Not just now it's the second ex parte meeting, but just the numerous errors, the numerous how can I say, just the numerous even the air conditioner don't get it. Just the numerous just mess ups, you know what I'm saying, and have this case still going on and on and on and on. I will say this though, I do see how the judge then whipped everybody into shape, especially the prosecution. She over there complimenting Miss Love. Oh, Miss Love. Oh, now you trying to get things done by the day. Oh, I love that. I love to hear that. Like, come on, bro. But I mean, that's what she's supposed to do. You feel me? At the same time, it's a court of law, so everything should be, you know, properly taken care of the right way. You know what I'm saying? And I'm not even mad at the judge, yo. Like, this is a big significant change from Judge Glanville. You see how I just dropped that from Judge Glanville? No, you know, Judge Glanville, his ass, he was letting a lot of shit slide. You know what I'm saying? He was leaning on some shit, but he was letting a lot of shit slide from the prosecution angle. And he let things slide from the defense, but this judge right here is no games, and she's having fun while she's doing it. Laughing, giggling. She's just, you could tell she lived for this. Judge Glanville was like getting irritated as fuck. Like, he didn't even want to be there. He was taking comfort breaks every 5 to 10 to 15 minutes, and his breaks was way longer than he, you know, saying they were going to be. Man, it's a whole new ball game at this point. But I did hear when she was talking about, she said if she does find that, you know, the ex parte meeting and everything like that was in violation of the codes of the court, then she will grant mistrial. She literally said it out her mouth, and that's her second time saying it, but she literally said it that time, I will grant. So she ain't even gonna play with it. So let something come back from that ex parte meeting that ain't right. She will. She said it herself, I will grant the mistrial. You know what I'm saying? And she knows that's what everybody want. Well, not everybody, but the defense, everybody on the defense want. So kudos to the judge for actually being an involved judge, a fair judge, or how they call it, impartial. Yeah, we're gonna have to see what happens from this point. This is day 103, and it's a little bit more left to go. I just like to give y'all a couple updates as the trial goes on. And yeah, man, like, comment, subscribe, and let me know what y'all think in the comments. I'm about to go get my workout on, check on my water. And you should go work out too, man. Health is wealth. The sun is out. Get outside. Don't just stay up in the gym. Get outside. Go jog. Go run. Go do some calisthenics. Go do some pull-ups. Whatever you got to do. Ride a bike. Like, comment, subscribe, notification bell. I'm going. Yeah.